Hello, everybody. Hi, Billy. What do you say? Should we show everyone? I love this so much. I love it. Billy O.T., attorney at Paw. I had to. I just had to, and I had to share it with all of you guys. I love it so much. Hello, Joey Bag of Donuts. Oh my gosh. Thank you so much. I appreciate that. I saw that you've got blankets in the dryer and you're going to cuddle up all nice, cozy, comfy, and warm. That actually sounds delightful because it's freezing outside here. Hello, Buzzy Pug. Hello, Nana Laura, honey. Hello, Bill Crayer. Oh, thank you so much. I know you're trying to hit Bill. Here, let me give it a shot. Hold up. Hold on, wait. Oh, I know. Oh, hold up. Oh, you just gotta wait for 2 seconds. I gotta try to hit Bill. Hopefully this doesn't cause reverb. Pause quick. There we go. I did that. All right. Ready? Cross your fingers, Bill. Let's see. We got Ian Wilson, Pumpkin Ann, Marie Mo, Terry, Jobertson, and Wolf Lore Lover. Oh, wait, no, I didn't get Wolf Lore Lover. He's just saying hi. I'm sorry, Bill, I tried. Oh, I love you. You are the sweetest. Hello, Richard Head. Oh, I got some good stuff. Oh, yeah. We got to do that. We've got to do that. Blue Buffalo. Are you ready? We've got the baked with bacon, egg, and cheese Blue Buffalo. And she's got her nose going up in the air. Oh. She's like, Mama, you almost forgot me. Even though I didn't. If it just goes longer than a second and a half, she thinks I did. Hello, Karaoke Rod. Palmy. Oh, Palmy. He is the absolute biggest Seahawks fan I have ever met. Absolutely. Yes. He has like a man cave absolutely dedicated to Seahawks. Yeah. I've seen pictures. Hello, C-Rex. I decided to come on a little early tonight. I figure if I'm not too tired by the end of this, then we can do, I've got a lot of body cam videos in the playlist. A lot. A lot, a lot. Hello, Eileen and Carlin. Hello, Linda Applegate. Hello, Jerry Matthew Boyd. Hello, Charlie. I know. Thank you guys for being so patient with me. Oh my gosh, thank you so much, Linda Applegate. I really appreciate that. Hello, Wolf Lore Lover, my love. You like the Billy O.T.? Yeah. Attorney at Paw. Absolutely. Let's see here. I think, did I get everybody? Oh, hello, Chris. Oh my gosh, good. I'm really, really, really praying that it's gonna go well for him and you. Really? You just noticed that? It's been there forever. It's been there longer than you've been here. I'm kind of a little bit of a Trekkie fan. Just a wee little bit. And I do a whole lot of frauditors. I do lots of Karens and as many soft sits as I come across. All right, I'm all caught up. Tuna at paw. As funny as that is, I think there's a large crowd that just wouldn't get it. But that is cute. Oh no. I know. I was teasing. Everybody here is used to me being like a minute or two late because, Ava has to potty or, Billy, why are you laying on my phone? If you call someone, here, let me just, come on, give it. Thank you. Oh, it's plugged in. Okay, well, let me put that there. Please don't call anyone. What are you? Well, you're crazy Uncle Jerry. Always fashionable. And always late. So yeah. Live long and prosper. Yes, he is laying on it because it's warm. I know that. because it's always being used. And it smells like me. Okay, guys, we are going to start. And the first one is Judge Braun. I don't know if you guys remember him. He, I don't want to say replaced, but I mean, he's no longer a judge. But I happened to come across him losing his ever-loving mind. We have a woman arguing color of law. And then we have a married couple that is trying to sell a trailer home. And it ends up being quite interesting. It's a twofer, 2 hearings. And then we have a judge that has me screaming at the screen. So I did y'all a favor, and I wrote my commentary because otherwise I would be pausing it every 3 seconds to rage scream at this judge. I'm not kidding you. She made me so mad. That's why I had to put her at the end of the docket. You can even ask Squishy, because he caught me screaming at her in the chat during the live, or during when she was holding court. Yeah. Hello, Spider-Man. I did send you the cat signal, Jerry. All right. Come on. I still have not emptied my files onto my external drive, so it's still taking just a minute to load. And today is Monday.
Matthew Molliker, case numbers 14 CR 205. Announce appearances.
May it please the court, the state appears by Aaron J. Cunningham, Assistant Ellis County Attorney via Zoom.
May it please the court, the defendant Keaton Molliker appears via televideo conference and with court-appointed counsel Alex Herman and McCoy.
Ooh, did you see that look the judge gave him, by the way? That wasn't a good look.
This matter's back to the court on an order of remand from the Court of Appeals. The court has reviewed the file, the transcripts, the various pro se pleadings that the defendant filed, and both sides ready to proceed.
State's ready.
I believe so, Your Honor.
All right. Well, I think I'm going to short circuit this. Mr. Molliker's argument is that he was not advised that he had the right to appeal from his probation revocation in this case. Is that correct, Mr. Molliker?
Yes.
All right. So you're saying because you were not specifically advised on the record by the judge and that your retained attorney at that time, Paul Aller, did not advise you that you had the right to appeal, you didn't appeal, and you would have appealed had you been advised of that, correct?
At the time, actually, back in the, several.
That's a yes or no question, Mr. Molliker. Your argument is, had you been advised, you would have appealed, correct?
Yeah.
Now, let me ask you, what would you have appealed?
I would have appealed the probation revocation.
On what basis?
Definitely the post-release term, considering it was a conviction that was based upon charges filed to July 1st, 2013, which required no post-release upon probation revocation, which I was ordered to serve a period of post-release on. I got a copy of the plea agreement.
This was a mediated plea agreement, was it not?
Do what?
This was an agreement. Well, okay, go ahead.
The original plea agreement filed September 15th, 2014. The state was actually at the time saying my criminal history was going to be agreed to and stipulated as G, even though I understand the court has the ability to sentence based upon actual criminal history. I believe the plea agreement, even at that time, on page, it's second to last page. There's not even a provision. It says guilty or no contest. I signed it, but there's nothing that actually says I pled guilty or no contest there. However,
Well, you're not appealing the original conviction in
yes,
the.
I understand. I'm appealing the probation revocation, which is
Right.
it's a domino effect from the original conviction, several other things, jurisdictional wise, I believe.
You're appealing, you're saying as on your affidavit and your motion that
Yeah.
your appeal is because you were not advised by your attorney or the court at the time of the probation revocation hearing that you had the right to appeal, correct?
Yes.
All right. And now you're saying that your argument is the post-release supervision, not the actual probation revocation, correct?
Well, it's definitely the probation revocation because that
What would you appeal on that?
any appealable issues, any meritorious.
What is it? That's exactly right. What is your meritorious appeal issue on the probation revocation?
There's several of them I ran across on different case law.
What
and
is
also
it?
at the time I had an attorney, and I believe I have an appeal attorney right now, which could perfect the appeal, which I would have to.
I didn't ask you whether you could perfect it. I asked, what issue would you appeal from the probation revocation?
The court's jurisdiction to revoke me.
What argument would you have? You were on probation from the Ellis County District Court. You're saying the court didn't have jurisdiction?
Potentially not. I mean, without actually going into everything, and
I want you to go into everything because I've reviewed the record. I got this remanded back from the appellate courts. I want to know what you were going to appeal from this probation revocation hearing.
I believe the case law says I don't even have to prove that my appeal would be successful upon a appeal.
You have to show that you have grounds for an appeal.
I don't actually. According
You don't have to show you have grounds? Maybe not.
to State versus Barnett and State versus Batista, I believe. Hold on, I actually got the citation here.
I don't need a citation. I need to know what legal basis. And Mr. Monaco, you are flooding the court with pleadings. They're well drafted. I'll give you credit. You've got a lot of time on your hands. You're doing a good job researching. You're wearing everybody, you're filing lots and lots of motions, lots and lots of appeals. I want to know what you're appealing because here, I'm going to tell you what the record is. And you've read the transcripts, all of these expenses that are associated, preparing transcripts and appeals and appointing attorneys. And you were on probation. And while you were on probation, you were convicted in the Teal's truck case, which was 15 CR 502. Well, no, actually it wasn't. It was the Teal truck case. We had so many cases, it's hard to keep track of the numbers. While you were on probation in 14 CR 205, you got convicted of a new crime, correct? Yes or no?
I was convicted, yes. Not by my, I didn't even.
You were convicted. And at your probation revocation hearing, page 4 of the transcript, I said to you, Mr. Moliker, I said to you, after being placed on probation, you were convicted in the Teal's truck case. You would agree that's a violation of your probation in 14 CR 205, would you not? What was your response?
I believe I said yes.
You said yes, sir. You said yes, sir. You were even respectful. You agreed your new conviction was a violation of your probation in 14 CR 205, correct?
Yes.
So you're convicted of a new crime while you're on probation. What are you going to appeal?
Whatever the appeal court can, or whatever the appellate lawyer can find. I believe since we're back on a remand for Ortiz hearing, the only thing would be to assess whether or not I was advised of my appeal rights.
There is,
I was or was not, and whether or not I directed my attorney to file one, which Aller told me he was going to take care of everything, and he didn't. I'm pretty sure several of the motions before the courts provide several ineffective assistance claims, even though Aller's not here, and I'm 1507 out, I believe, time limit wise. I definitely know if Aller would be practicing today, I would definitely have some severe malpractice claims against him.
He is practicing today. But the bottom
Well,
line is
the letter he sent.
you were on probation and you committed a new crime and you were convicted of it. And that is by law grounds to revoke your probation. You have nothing to appeal. Not only that, but by agreement, you were given credit for all time served in some additional time that you requested, which covered your entire sentence. You got, the journal entry shows that you received full credit. It was a 9-month sentence and you got 274 days credit. You have no sentence to serve. It was all explained on the record and you agreed with all of it.
And that was what date? Was this revocation? Because I believe at this point we've exceeded the scope of Ortiz remand, but I guess.
No. Ortiz, whatever name you want to use, you've got nothing to appeal. All you're going to do is exhaust limited resources in the state of Kansas. I'm not going to give you, you're not going to get appeal. Take it back up again. Let's see what the appellate courts do. You've got no sentence to serve. It was an agreed upon disposition. You committed a new crime while on probation. All of those grounds were in. So that's the law. Okay.
If he gets his appeal, can they give him time? Can he I mean he's got no sentence to serve from this one. Can they redo his trial and give him more time? That would be wild.
So
Ortiz says you have to have something to appeal. You can't even come up. You're saying, well, whatever they can find that I can appeal. You don't even have grounds for any appeal.
Okay, on that comment, so I don't have grounds to appeal. However, you're claiming that the jurisdiction of the court existed on the August 2016 revocation hearing. However, since that, let the record reflect that, I was fully revoked April 21st, 2016, prior to any revocation occurring in August. So the court abused its discretion, exceeded its jurisdiction on even revoking me August. So yes, I do have grounds to appeal and set aside the August 3rd, 2016 revocation at this point.
Take it up. You're going to do it anyway. I mean, just go ahead. Mr. Herman, do you have any argument?
Nothing that hasn't already been stated, Your Honor.
Mr. Cunningham, anything you want to add?
Your Honor, just that I feel like a lot of this should be collaterally estopped under res judicata anyway. I feel like we've litigated these issues previously. Obviously, he doesn't like the answer that he's getting, but if the court even has jurisdiction to weigh in on these issues, I think the court has adequately summarized what the state's position would be. In regard to the Ortiz remand, I guess the state would request that the court find that there are no Ortiz factors present that would justify this, and that way at least the appellate courts know that we took up the issue and the court has made a ruling on it.
You know, there are no Ortiz factors. There is nothing to appeal. There were no grounds for appeal. All of a sudden now, I mean, the defendant himself said, well, I'm hoping that appellate counsel can find something. There's nothing to appeal. He served his sentence. He committed a new offense while he was on probation. Now he's sort of thrown out jurisdiction. There's no jurisdictional argument here. There is no argument, period. Why have Ortiz here? You know, I can't believe the Court of Appeals with all their staff didn't note that. There's nothing to appeal in this case. So I'm going to find there's no appealable issue. There's nothing for us to deal with under the Ortiz factor. If there is, I'm going to find that the Ortiz factors haven't been met. And
aspect, I would notify, since my last attorney didn't properly appeal everything when I asked him to, when he said he was going to, even told my dad he was going to. But I will notify the court today that I filed mine, or I would like Alex Herman to file my notice of appeal immediately. I mean, I understand from the appeal remand, they said, I gathered this ruling was going to be like this because they went into 5-paragraph detailing how to appeal this ruling. So I believe that was kind of
let the Court of Appeals try. You, like you said, you want somebody to find an issue for you to appeal. You said, I want the appellate lawyer to find something to appeal. Good luck. This is an example of where the use of limited state resources is abused. It's as simple as that. You have nothing to appeal. You're saying, I want somebody to find something to appeal. The appellate courts remanded back and said, well, find out this was all agreed to. Every single thing in this case was agreed to. You agreed to it. You have nothing to appeal. But while you're serving a lengthy prison sentence, which, by the way, I think you're eligible to get out next year, you have time on your hands. And so you are now gaming the system. That's what I'm going to call it. And you're doing a really good job. You filed you filed some excellent legal arguments, and it's drafted well. I hope when you get out, you use whatever skills you're developing to be a productive member of society, because you show a lot of potential. But the bottom line is you don't have anything to appeal in 14205. So under the Ortiz factors, I don't know how I'm supposed to even reach whether you were properly advised and all of that, because there was nothing to appeal. You'd already served your sentence. So,
and I don't mean any disrespect to anybody, no, the county attorney, Alex Herman, or the court, but you know, I'm confused even on the remand. So I guess, you know, no disrespect. I definitely hope you didn't take any. Nobody takes.
I don't have any disrespect. I'm frustrated because I'm having to spend an enormous amount of time going back on cases that are now how old? 2014 case.
7.5.
Yeah, I'm having to go back, and because of all these appeals and all this stuff going up, and yes, it's frustrating because I got a lot of current cases I'd like to deal with, but I have to get, and I don't want to deprive anybody of their lawful rights and legal arguments. That is important. But this was all an agreed upon disposition. And the end result was, the reason it was agreed upon was because you'd served your entire sentence. You were given credit that you requested. We added some extra days. And so it was like, your sentence is done and the case is over. And so I've made my ruling, and let's see what the appellate courts can deal with it as they see fit. Now, you have since filed a motion in 15 CR 502.
Yep.
I just received it. And instead of setting up another Zoom and appointing another lawyer and all of that, I'm going to deal with that today as well. Mr. Cunningham, have you reviewed the defendant's pleading?
I did, Your Honor.
Okay. Here's what it boils down to. The defendant requested at the state's expense, again, it was, I'm not sure you got billed for it, another transcript of the sentencing hearing on an agreed upon mediated plea agreement. And in that, at page 9 of the transcript, when I was sentencing the defendant, I said, for aggravated sexual battery, severity level 5, not drug felony, severity level 5 felony, the court sentences you to 43 months. Now, you're saying that's wrong because under the I-box, it should be 34.
34, yeah.
Correct. And you're correct. Okay.
Yep.
And you know what? That's exactly what the journal entry says. The journal entry for count 2, the sentencing journal entry, says 34 months. One of two things happen. The court reporter may have transposed 34 to 43. She may have done that typing. Okay. Because here's why I think that's a possibility. And maybe not. Maybe I just misspoke and I transposed in my language 43 to 34. Because then I said, all right, and for count 3, breach of privacy, level 8, 9 months. The 3 are to run consecutive for a total of 135 months. You read that. You ordered the transcript, right? All right. So guess what? 92, 43, and 8 equals what?
Definitely over the 135.
It equals 143 months, doesn't it?
Yeah.
What does 92, 34, and 8 equal?
135.
Correct.
Judge, if you hadn't have given him the answers basically before you asked the questions, you know he wouldn't have methed that out himself.
And that's the only reason I brought it up, because I know
So you were sent, the journal entry gave you the exact sentence you bargained for at a mediated
Yes.
plea agreement, and that's what you were sentenced to. But you want me to correct an illegal sentence that's not illegal, because the journal entry is absolutely correct.
I just wanted if there was the oral pronouncement of the sentence corrected to reflect what the journal entry said.
The journal
Just
entry,
so there's
correct.
no any future issues on it.
You can't probably see this, but I highlighted it. It says 34 months for count 2.
Yes.
That's exactly what you said it should be. That's what the mediated plea agreement said, and that's what you were given.
So the sentence on count 2 was imposed at 34 months.
Yes,
Okay.
I've got the journal entry right here. That's what it shows in your case file.
Okay.
That's what's reported to the Department of Corrections. They don't use the transcript of the transcript wasn't even in existence until you ordered it.
Yeah.
So there's no way it could be confusing. And it could be that, as I said, one of two things. Either the court reporter transposed, and I doubt she did it because she's very thorough, 34 to 43, or I misspoke at the time of sentencing, but then I went ahead and added them up, and it's the exact sentence you bargained for. And that's what's shown in the journal entry. And in fact, it shows in the journal entry the total sentence being 134 months or 35 months.
Yeah. I just wanted to that I mean, if that was an error by either her or misspeaking, which like I said, I understand everybody makes errors, we're only human, but that 34 months was imposed by you from the bench that day. So on count 2.
Well, I may have said 43, but the journal entry and all the records show 34, which you agree is the correct sentence.
Yes.
So again, your motion to correct illegal sentence, it was not illegal, it was accurate, and was pursuant to the guidelines. So in Mr. Cunningham, you may want to take notes down. I'm just taking this up because otherwise we'd have to schedule another hearing, and Mr. Herm would have to go review this whole file, and there's no reason for it because, again, the journal entry is correct. All right.
I do appreciate you taking that up right away. I mean, it was way quicker that way.
Well, and Mr. Moliker, I know that you had some frustration with the delay in some of these things being filed. One of the reasons for the delay is for a period of several months, our electronic filing system was down because it was ransomware attacked, and it was impossible to file. So documents were done, records were ready, but we couldn't file them because we didn't have the means or ability to do it.
I discovered that here later. So
right. And that was a legitimate question to raise, but I thought you were entitled to know that that's the reason they weren't actually filed till much later. For one of the other reasons that the order of remand wasn't filed until much later for the same reason. They couldn't file it because our system was down.
Okay.
Okay.
All right.
All right. Anything else for today?
I mean, I just had questions for Alex Herman, but I tried contacting him, but
I'll tell you what I think we're going to do. This is on YouTube, and we're making a record of it. What we're going to do is I'm going to have my administrative assistant take it off YouTube.
Yep.
And Mr. Cunningham and I will leave. And that way you and Mr. Herman can have a conversation. Mr. Herman has time to do that while you're both available.
Okay.
If not, you can schedule.
Crystal Joseph versus the Stamford Police Department. You there, Miss Joseph?
Yes, I am, Your Honor. Good morning, Your Honor.
Good morning. Just give me 1 minute. All right, Miss Joseph.
Yes, Your Honor.
All right, the first thing I'm going to take up with you is your motion to open the judgment. Okay.
Yes. And I respectfully
And hold on one
ask-
second. Hold on one
Okay.
second. All right, so this is a judgment that entered as a result of, I think there was a motion to strike filed. I had granted the motion to strike, and you, Ms. Joseph, then per the practice book have there's a time frame in which you are required or allowed to replead your case or your counts, and you did not do that. And so there was a motion for judgment that was filed. I don't think there was a was there a, all right, there was an objection, which I overruled at the time. So you can go ahead, Ms. Joseph. I understand that you are self-represented, and that's part of the reason why I scheduled argument on this. I'm certainly understand the predicament of being self-represented, so I wanted to allow you an opportunity to be heard on this. I would tell you, it's kind of an uphill battle as to why I would open a judgment, but I'll allow you to make your argument.
Okay, I appreciate that, Your Honor. Good morning, Your Honor. Good morning, Mr. Lee. I'm respectfully asking that the court consider the real and documented impact that prevented me from fully prosecuting my case and to apply General Statute 52-212A, consistent with Connecticut precedent and principles of substantial justice. The legal standard that I'm taking, Your Honor, under 52-212A, a party seeking to reopen or obtain relief must satisfy two requirements: that a meritorious cause of action or defense existed at the time of judgment entered, and that the party was prevented from presenting it due to mistake, accident, or other reasonable cause.
All right. You think she had someone write this for her, or did ChatGPT write it for her? Because she couldn't even pronounce meritorious. So I really doubt that she put this whole script together herself.
The Connecticut Supreme Court has repeatedly held that the statute must be applied equitably, not mechanically, and in a manner that promotes substantial justice, particularly where no prejudice results to the opposing party. Zakonski versus AMS 208, Connecticut 230, 1988. I have a meritorious cause of action. At the time the judgment was entered, I had and still have substantial claims involving failure to protect, ongoing misconduct and interference, property destruction and loss, emotional distress, actions taken under color of our members, actions of the Stanford Police Department. These claims were pleaded and supported, and the defense does not dispute that the allegations existed. They argue only that I did not prosecute them fully, which leads directly to the second prong: reasonable cause why I could not prosecute. Your Honor, I was not negligent, indifferent, or didn't abandon my case. I was forced to abruptly relocate for my personal safety due to the very conduct underlying this lawsuit. That relocation caused severe emotional trauma, financial devastation and instability, loss of housing continuity, destruction of access to records, evidence, and court communication, significant impact on my physical and mental health. Despite this, I continued filing, responding, and attempting to comply as a self-represented litigant under extraordinary circumstances.
Oh, she's trying to cry so hard. Mind you, she is suing the police department. They caused her trauma.
Connecticut courts recognize that reasonable cause includes situations where a party's ability to litigate is materially impaired by circumstances beyond their control. American Express Centurion Bank versus Head 115, Connecticut, at 10, 2009. This was not delay by choice, it was displacement for safety. Addressing the defense reliance on Mercedes-Benz Financial, the defense relied on Mercedes-Benz Financials versus Stratford Avenue, LLC, 344 Connecticut, 796/2024, but that case involved commercial parties and strategic litigation decisions, not a pro se litigant displaced due to fear for her safety and financial collapse. That case does not stand for the proposition that courts should ignore human realities or trauma-based impediments. Even Mercedes-Benz reaffirms that relief may be granted where compelling equitable reasons existed. Those compelling reasons exist here: equity, prejudice, and justice. The defense has suffered no prejudice by allowing this matter to proceed on the merits. I, however, face permanent loss of rights if relief is denied without any education of facts. Connecticut's courts favor resolving matters on their merits, not on procedural collapse caused by trauma, displacement, and financial hardship. That's Rogers versus Hartford, 184, Connecticut 150, 1981. In conclusion, Your Honor, I respectfully ask the court to recognize that I had a meritorious case, that I was prevented from prosecuting it due to reasonable documented cause, that equity, fairness, and substantial justice support granting my motion. I'm asking for leniency. I'm not asking, and I'm asking for access to judgment. Thank you, Your Honor.
All right. Ms. Joseph, let me just ask you a question. So you had filed, it looks back in early November, you had filed a motion to consolidate. You also filed an objection to defendant's motion to dismiss. Now, the motion to consolidate, as I read it, it seems to be asking for the same thing
Yes.
in terms of it seems to be asking for to basically reopen the judgment as well. And then your motion, your objection to the motion to dismiss seems to be arguing all the same points as well. Am I correct on that?
Yes, Your Honor. I'm asking for the matter to be governed by General Statutes 5212A, which requires a two-part showing that a meritorious cause of action existed and that I was prevented from prosecuting it due to mistake, accident, or other reasonable cause.
Well, let me ask you this. You know, what prevented you from? You indicated that you hardship, and what's the specific situation that prevented you from refiling after the motion to strike was granted?
I was forced to relocate due to safety concerns resulting in financial distress, emotional trauma, and inability to access certain of my records because they were either stolen or destroyed. And it's just the circumstances beyond my control that materially impaired my ability to litigate. It's different from neglect because neglect is a choice that was displacement under duress. I did not abandon the case. I continued to file motions and seek relief, dispute instability, and hardship.
Okay.
And Connecticut law favors decisions on the merits where compelling equitable reasons exist, no prejudice results. Denial here would permanently extinguish my rights without any factual determination.
Yeah.
And
so you were forced to relocate for your safety and for financial reasons. Is that what
Correct.
You indicated?
Correct.
Let me ask the question.
Okay.
What safety concern did you have?
I was being harassed by the Stanford Police Department. I also had issues when I came down to file certain motions by members or agents of the Stanford Police Department in the courts. My car was being tampered with. Certain court clerks was not affording me. They were separating certain documents that I wanted to go in as packets.
So wait, the safety threat that you're indicating is the Stanford Police Department and I'm sorry, did you say
The marshals.
the clerks?
The marshals at the, yes, the marshals at the courthouse. Yeah, they threatening of arrest. They
You mean the judicial marshals that work here in the courthouse?
Correct, Your Honor.
Okay. So the being forced to move was a result of actions by the Stanford Police Department and the judicial marshals that work at the courthouse.
No, not the judicial marshals, just the Stanford Police Department was in that action. But as far as like, I had to move, relocate, and I didn't have stability, housing stability. I was commuting back and forth from New York, trying to get my life back together. And, it just was a disrupt for me to file certain documentations on the, it was hard. It made it almost impossible for me to,
Right.
do what Mr. Lee was.
I'm just, hold on a second. I'm just trying to get an understanding of that. You indicate that in your motion that you had a hardship, and now you're arguing that hardship was because you had to relocate. You do indicate that you had to relocate for financial reasons, but you're also arguing that you had to relocate because of harassment by the Stanford Police Department.
Yeah,
and that's the hardship as to why you couldn't replead.
I'm arguing that I was forced to relocate due to safety concerns.
Right, and I understand that, and the safety concern that you had was the concerns for your safety. Those concerns were stemmed from actions by the Stanford Police Department.
That is correct, Your Honor.
Okay, all right, that's what I was trying to get about. Okay, and what I'm going to do is, in considering this, I'm going to consider all your arguments under your motion to open judgment, because it seems to me that your motion to consolidate and your objection to a motion to dismiss, which I don't know that there was a motion to dismiss, but those make the same arguments. Am I correct that you're arguing the same things in those motions?
Yes, it's an objection to the motion to dismiss.
All right. Okay. All right, Attorney Lee.
Thank you. Thank you, Your Honor. I don't actually think that there is any basis, and I don't find the argument that the plaintiff was unable to comply with the practice book requirements to be persuasive. We have the motion for judgment was filed on July 31st. So we have the motion to strike was granted on July 11th. That's when the court said the reason why I'm striking it is because the police department is not a valid entity that can be sued. Plaintiff was informed of that. 3 weeks later, I waited an additional week. I filed the motion for judgment on July 31st, 2025. If I recall correctly, that either came up or it didn't come up until I reclaimed it after that, and then it came up for the short counter on August 27th. And it wasn't granted by the court until August 27th. And you'll see that in between, where the plaintiff claims that she didn't have any time and she had to relocate all that. There was a request to amend a complaint filed on August 11th and an amended complaint filed on August 11th. And the objection to motion also filed on August 11th. So Billy had the ability to file things with the court in and around that time that she's claiming. And I just don't think that having to relocate is a valid objection to or a valid explanation as to the reason why she couldn't simply file an amended complaint that complied with the court's order. So, for these and the other reasons that I've put forth in my brief, I request that the motion to open be denied.
All right, thank you.
Yeah,
Hold on, Ms. Joseph, I'll give you a minute or two just to respond quickly. So go ahead.
Your Honor, this name of the municipal department is correctable by amendment under the Connecticut Practice Book Rule 1060 and is not grounds for dismissal where the city had noticed. Basically, Your Honor, even if the department itself is not a separate legal entity, the claims are against municipal actors. Connecticut law permits amendments to correct the party's name where the municipality had notices and no prejudice result. Police department, as far as it's not a legal entity, the defense argues that the Sanford Police Department is not a legal entity capable of being sued, even if the court accepts that as a technical point. It's not grounds for dismissal of the action. Connecticut courts consistently hold that when a municipal department is improperly named, substitution of amendment is not dismissal, particularly where the municipality had notice and no prejudice result. Under practice with 920 and 1060, misnomer improper party designation may be corrected by amendment, and courts favor allowing amendment to reach the merit.
What's amazing is you absolutely know she's reading a script. So someone had to put this together for her in flowchart fashion. If attorney says this, you read this. If judge says this, you read this. Because how else is she following along with this script so well?
Here, the city of Sanford had notice, is represented by counsel, and would suffer no prejudice by substitution. Dismissing the case on a naming technicality would elevate from over substance and deny my access to judgment. I respectfully request leave to amend the substitute the city of Sanford and to proceed against John and Jane Doe officers in the individual capacity for acts taken under color of law.
All right. Thank you, Ms. Joseph. Thank you, Attorney Lee. I will take the papers and I'll issue a decision as soon as I can. Okay.
Thank you, Your Honor.
Okay.
Thank you, Ms. Joseph.
Thank you, yeah. Thank you.
All right. Listen, you all have a great day, and
You too.
Again, happy holidays. All right.
Same to you, Your Honor.
All right.
Thank
All right.
you,
Take care now.
Thank you.
Can you hear me now?
Yeah, I can.
Okay.
A lot of buttons.
Glad we got it figured out. Your hearing starts very shortly.
Yeah.
I'm sure the judge will pop in soon. I do not see like the plaintiff is here at all yet.
Okay. What happens if he doesn't show up?
The judge will address that. Let me see here. If you say in the calendar, who's motion for this one?
Okay, let's go ahead and go back on the record. I will take up the 1015 matter, which is Schaub versus Schaub. file 20-35195-DO. It's the time, date, and place set for an order to show cause. This court issued an order on March 20th of 2024 to the plaintiff to appear today at this hearing. With us, we have the defendant, Ms. Laura Schaub, and I don't see that we have the defendant with us. Ms. Schaub, you can see and hear me, is that right?
Yes, I can, sir.
All right, and are you aware as to the location or status of Mr. Schaub?
All I know is that he's in Florida, and I know that I know that he got the message, even though if he didn't get the letter right away, because he had his address here. He hasn't been here in 4 years. He walked out a month after, and he made all these promises and didn't keep up to any of them. And I've been like drowning here.
Let me stop you for just a moment. Okay, we'll do one thing at a time. How do you know that he received this message?
Because I texted it to him, to his number, and then his sister always wants to be in the middle, so I texted it to her, and he come back with some not so nice comments toward me. So
okay, bottom line is he communicated with you at that same time, so you have reason to believe he received this information. Is that correct?
Oh yeah, I know he did. Yeah.
Okay. All right, I set this matter because you supplied a letter to the court indicating that you had not been able to take action with regard to the order of divorce in this case, specifically with regard to the sale of the property. That is the property that's owned in the marriage. And you indicated that was because the plaintiff has not been in contact with you. His name remains on the deed. Is that what I'm hearing from you?
Yes, sir. Yes, sir.
All right, let's go ahead and put some information on the record. And when we do that, that'll give me the ability I need to make a decision as to where we go from here. So please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Schaub, you were the defendant in this divorce action, correct?
Yes.
And in the judgment that I entered in May of 2020, it was indicated that you and your husband, the plaintiff in this action, would sell the property that was owned by both of you and divide the proceeds of that sale between you. Is that correct?
Yes, sir.
Have you been able to do so?
No, sir.
And the reason for that is you've explained to me because the defendant has not been cooperative with regard to providing.
Mr. Schaub is now here.
Oh, he is. Good.
I'm asking him to unmute and start his video. I'm just waiting for him.
Okay.
Okay, you're Mr. Patrick Schaub, is that correct?
Yes, I am.
And you are the plaintiff in this action, correct?
Yes, sir.
All right. Well, I'm glad you appeared. We also have the defendant, Ms. Laura Schaub, with us today. The reason I ordered you to appear today is because I received a communication from the defendant indicating that the property that I had ordered to be sold by the parties as part of the resolution of this marriage has not been sold. She's indicated to me that the reason for that is that she has not been able to secure your signature either on the deed or to pursue the sale of that property. Mr. Schaub, are you able to go ahead and participate in the sale of the subject property?
Yes, sir. We actually had signed papers just past week to go ahead with the realtor to open on the market.
All right, just a moment. Ms. Schaub, is that accurate?
Yes. It's been on the market, and there's been for sale signs everywhere.
Well, wait a minute. So the property has been marketed for sale, Ms. Schaub. I don't think that's what you told me. Is that right?
No, it's on the market. It's with Bowman Realtor.
Okay. Then Ms. Schaub.
But he just recently, when I relisted it with Bowman, that's when he jumped on the boat. That's when, and then I got the letter in the mail that he was in contempt. The point is he has not paid anything to fix up, to help, to do anything until it inconveniences his little life. I'm not the one that ran away from this marriage. I'm not the one that wanted it to end, but he sure was. And
All right, so let's stop for just a moment. You've indicated that you haven't received any payment related to the property. The order indicates that both parties are responsible for the mortgage, insurance, taxes, liens, and any other costs or debts associated with the property. What do you argue or allege that he owes you then for those payments since the entry of the divorce order?
well, he hasn't paid anything. We're like, I mean, I'm trying to keep it out of foreclosure. If it goes in foreclosure, we both lose.
So what?
He's not paid a single tax. He
Okay,
didn't pay for the plumbing.
Stop, okay?
Okay.
I need you to listen because we're recording this, so we can't talk over each other. And I know that this is emotional, but my job is to get past the emotion and make a good decision based on all the facts and evidence, okay? So you need to answer my questions and not go into a statement about things. So
Emotional? Just a wee bit. Come on, guys. Michigan with her or Florida without?
be specific. What are the amounts that you are owed? It told me that you've made all the payments on the property since the divorce. And how much is that?
So far it's over $700 that I've paid toward the taxes to try to keep them up. I'm on disability, kind of hard to do, but I'm doing it.
Okay, hold on. So you don't know the exact number today. You're in court, you don't know the number, is that right? That's a yes or no?
Hold on a second.
How about the mortgage payments? Let's start there.
We don't have a mortgage. It's just taxes.
Okay. Insurance?
No insurance.
All right.
It's a trailer. Just the what? You cut out.
Boy, you just need to wait for me, okay? We're talking over each other, and that makes for a very, very difficult record. So just wait and respond to my questions. So in terms of the taxes, do you know since 2020, when this matter was resolved by order of the court, how much you've paid in taxes?
$740.
Total?
Total.
So what you're seeking is payment by the plaintiff in the amount of 1/2 of that. That would be $370, correct?
Yes, sir.
All right. And are there any other issues with regard to expenses associated with the property that I need to be made aware of now that you're seeking recovery for?
The plumbing was done.
And how much was that?
Total plumbing was $530.72.
Anything else?
The septic was $618.
Anything else?
Propane tank was put in at $100 deposit.
So the trailer uses propane for heat, is that what you're saying?
Yes. I've had the furnace had to be fixed twice. That was $150.
Each time or total?
Each time.
Any others?
Nope.
Okay.
That's it.
All right. So Mr. Schaub, do you dispute any of those charges?
Yes, sir, I do. When I moved away into 2020, in October of 2020, I moved to Florida. At that point there, I told her that we're going to have to sell. It's best that she just leave the place. We'll sell it. Until that point, there was no communication as far as how much it was. She wanted to dictate how much she wanted to sell it for, which was fine. We can dispute each other over price. In 2021, I paid the back taxes of, I believe it was between $1,600 and $1,900 for 20, I believe it was for the 2020 taxes, which was overdue.
How much was that you paid? If
You
you're
know, I really,
guessing, if you're guessing,
I'm
it's
guessing
not-
between $1,600 and $1,900.
Right, so you don't know exactly what you paid, is that right?
No, sir, I have not been able to look up the records. I know it's in there someplace, Grand Traverse County records. Most of the lists, most of the taxes that were paid on that property were paid by me throughout our years of marriage.
Why don't people understand that the time to have these numbers and this evidence is during court, and you're in court? So why don't you know the answer to how much you paid in taxes? Why didn't you get that information prior to court?
All right,
I owned the place before we were married.
so let's talk about the expenses associated with the upkeep. I understand you wanted to sell the property immediately. It wasn't sold. Not much I can do about that. That's history. And
Yes,
the
sir.
property was retained by both of you, technically, according to the order, for these 4 years. So the expenses would normally be distributed evenly amongst you. Are there any issues that you have with regard to the amounts that were paid here?
Yes, sir. She chose to live there. As far as I understand, with the divorce decree, says that we're responsible, split evenly between the mortgage, liens, taxes, insurances. As far as living expenses, she chose to stay there and live there. So it's up to her to upkeep, in my opinion. Because her toilet breaks down, sir, I don't see where that's my responsibility.
I understand. I completely get your position, but your order says that any costs associated with the property are to be split evenly between the parties. I recognize you're living in Florida. You don't know what's going on with the property, but that was the order that you signed back in 2020. So look, guys, here's the reality here. The taxes, the total taxes that have been paid since 2020 need to be calculated. Once they're calculated, they're divided evenly between the parties. And if the taxes, let's say hypothetically, are a total of $4,000, then the division is $2,000 each. If one party has paid more than $2,000, that party is entitled to receive payment from the other party. It sounds like both parties have contributed to the taxes since 2020. So somebody's going to have to do that and get that information. It's not me. You need to come to court and be prepared to give me that information. And once I have it, I'll certainly order the other party to make that payment. That's number one. Number two, with regard to the expenses associated with the property, I understand the plaintiff's concerns, given that he hasn't been living in the property. But the reality is the order that was entered back in 2020 is your order. It's what I've got to follow. I can't create it out of whole cloth. I have to enforce your agreement. And that agreement says that the expenses associated, the costs associated with the property are to be split evenly. That means that the plumbing, septic, propane, and furnace expenses are to be divided evenly between the parties. At the end of that, we will determine exactly who owes what to whom. But I need to know, and I don't have enough information before me today, exactly what it is that is owed by the parties. So here's what we're going to do. Ms. Schaub, I'm going to go ahead and reset this matter for hearing at my next hearing date, which will be sometime in May. And we will, at that time, expect that you and Mr. Schaub will have all of your ducks in a row with regard to the payments that you've made. And those payments are going to relate to the items that you've told me about today. Taxes, number one, since the date of judgment, which is May, just a minute, let me get the date correct here for you. which is May 4th of 2020, and the expenses that you've described to me, the plumbing, septic, propane, furnace. We're not going to deal with anything else, just those. So I need the tax amounts, who's paid them, and I need proof of the plumbing, septic, propane, and furnace. And we'll come together, we'll figure out exactly who owes what to whom, and that will wind up being an
Grant, you just kicked out
Yes.
Judge Elsenheimer.
All right, I'm not sure why I was kicked out. My apologies, but I'm back. That will wind up being an order of the court, and the parties will be responsible for paying or amounts. Are there any questions, starting with you, Mr. Schaub?
Yes, I have quite a few questions. The situation that's in hand, that we are trying to sell the place, it was listed in the market for $79,900 with Lori Bowman of Bowman Realty. The price and the paperwork were signed. Miss Schaub there, Miss Brown, I don't like her having my name. Miss Brown has told the realtor to take it off the market until after this hearing, and then proceed to tell her that she wants $100,000 for the property.
It's a trailer. I don't understand the 79.9, but $100K for a trailer? They better have some gold rims on them wheels.
Which is astronomical, and it's unreasonable. I don't believe we're going to go anywhere further than this if we cannot come to an agreement how much we're going to sell this place. I've already, in that situation, have told Lori Bowman that Laura has come to me and says she wants me to pay the closing costs. She wants a half of this, she wants half of that. I went ahead, and because I want this behind me, I agreed on paper with my signature and hers that we will sell the property, split the cost, and I will cover any of her expenses that was incurred with what I have to pay. We've done this. We've already here. We're at that point of doing this now. Why I was called into here now, I have no understanding. I've paid the taxes there for over 20 years. If anybody hasn't paid the taxes, it's Laura, and I don't.
All of this will come out in the wash when we have this hearing in
Okay.
about a month, because you're going to have all that information, as will Ms. Schaub. You'll present it to me, and I'll use court time, valuable court time, in order to resolve something that you guys should have resolved 4 years ago.
Yes, sir.
In terms of the sale of the property is going to be sold. So if one party or another is artificially inflating the price of the property in order to avoid sale, well, that's not going to stand. We're going to get the property sold so that the parties can move on with their lives. And that means that Ms. Bowman may well be charged with coming up with a price that will be attractive to a buyer, an arm's length buyer in the county in which it's located. Okay. But that's something we'll talk about more in the next, at the next meeting that we have, as I said, in 1 month. Any other questions, Mr. Schaub?
No, sir.
Ms. Schaub, do you have any questions?
You know darn well she kept his last name just because it made him mad. Because when he said, Miss Brown, I don't like her having my last name, she went,
No.
Okay, we'll set this matter for a continued hearing in 1 month. I want the parties to be prepared to give me the expenses only on those matters I've discussed. We're not going beyond that. And we'll come up with a number. If you want to communicate with each other and figure it out ahead of time, feel free. But at a minimum, we'll plan on doing that when we meet again in 1 month. I'm requiring that both parties attend, so if you fail to attend, you'll get notice from us as to when that is. If you fail to attend, you may be held in contempt of court. Does everybody understand?
Yes, sir.
All right, very good. We'll see you in a month. Thanks, everybody.
Thank you.
Thank you.
Good morning, Ms. Schaub.
Good morning.
Good morning, Mr. Schaub. Judge will be here in just a moment.
Okay. It's saying Paul Schaub. My name is Patrick.
Hi, Patrick.
My apology.
No worries.
Okay, welcome everyone. Let's go ahead and go on the record. This is Schaub versus Schaub, file 20-35195-DO. Time, date, and place set for a hearing on an order to show cause, the allegation being failure to comply with judgment. We have with us the plaintiff, Mr. Patrick Schaub, the defendant, Laura Schaub. Ms. Schaub, I believe you filed this request, unless I'm thinking of another file, seeking to have a hearing on whether or not there's been compliance by the plaintiff, Mr. Patrick Schaub. Let me go ahead and hear from you, Ms. Schaub.
He hasn't paid any of the taxes that are in there right now. And I've been paying the taxes, what I can pay on them. I'm on a payment plan. But every time that I pay and he doesn't pay, they charge a fee. So I think it's only fair that he pays for that fee along with the maintenance that I've done.
Okay, so what do you allege that he owes for unpaid taxes and maintenance? And we'll talk about maintenance in a moment.
Taxes and fees is $1,392.74.
All right, and what kind of unpaid, or pardon me, what kind of repairs have you made to the property?
Emptied the septic tank, redid the plumbing, redid the furnace, and I had coin come in, but I'm not worried about that because so the total half of that is $724.36.
All right, let's hear from Mr. Schaub. Mr. Schaub, do you disagree with these amounts?
As far as disagreement, as far as paying the taxes, I don't disagree with. I guess the whole idea is that taxes are being paid on a yearly basis. I've always had my taxes 3 years back, actually default taxes for the past 3 years. My last payment.
Oh, now just a moment. Hold on.
I'm sorry.
Hold on, both of you. Yeah, we're making a record here. This may not seem like court because you're sitting at home, but it is. So nobody interjects. Nobody comments while the other person is talking unless I allow it, okay?
Sure they do, Judge. I don't know if Michigan is the same as Wisconsin, but in Wisconsin, when you get to that third year, it is your final year on taxes. The moment you default that fourth year, the property is owned by the county or state. Why would you just let the taxes build up for 3 years? What if you ended up hospitalized around the time that you needed to come up with the financial payment of the 3 years of back taxes, and then you just lose your property? You are a dingus.
So only respond when I've asked you a question. Mr. Schaub, back to you.
Yes, sir. Last payment I made into taxes was in 22. That was for the 2020 taxes. If you look in my records, you see that I've always 2 years prior, or 2 years paying back taxes. So I've been paying these taxes since I've purchased the property from my father. My last payment was in 22 for a payment of 18. Oh no, I'm sorry, for a total payment of $1,119.67. That was paid in 22 for the 2020 taxes. This time around, she has been paying the taxes. I've been getting the receipts, and I see that she is paying the taxes. As far as paying my fair share, I believe I paid my fair share since day one. For the sale of the property, most of those taxes will be paid within the sale of the property. So I haven't been really too worried about it. In other words, taxes are being paid. I'm glad that she is paying them. I commend her for that. That's a first. But also, as far as the maintenance goes, if there are things to that point where septic tank, plumbing, I don't know what happened. The furnace was recently renewed. I'm not really too sure about some of those things. I've asked her to leave. We wanted to sell this property since we were divorced. I moved to Florida to rectify the system of let's get this rolling. She chose to stay there. So anything that breaks down while she is there, if it's legally that I am binded by having to pay half, I have no problem with that. It's just that I don't believe those things would have occurred if she had moved and we just sold the property. She chose to stay there, and that's her prerogative, I suppose. But I'm not contesting that I have to pay half of anything. I agreed in the divorce that we will sell the property and we will split it 50-50. And that's including taxes. Now, the maintaining of it, that's in everyday life. When you own a home, you must pay for those. And I have, and I've shown that. I don't have the receipt of the furnace, but I know the furnace is fairly new. I don't know what broke down on it. I guess is what I'm saying. I'm happy with it. I'm fine with paying half. I'm not disputing that.
Okay.
I really don't know why we're even here, because we're grown adults. We could take care of this. I don't know why I'm getting, sent to court to pay something that I've always agreed to pay to.
All right. Did you have anything else, Mrs. Schaub?
Yeah. As far as the last 4 years is what we're talking about, he hasn't paid anything. The last payment he made was in 2019 on the taxes. And he's the one that put the 50-50 in there: insurance, maintenance, taxes. Well, I do everything I have to do. And he sits in sunny Florida saying, oh, no, I don't have to do that. Isn't this divorce paper law?
Okay, Ms. Schaub, I need to ask you about the taxes. Is the tax amount money that he owes under his 50% to the township or the county, or is that money that you think he owes to you that you've paid?
Half of what he owes to me.
All
like
right.
what payment I made, like I made a $75 payment, that's cut in half to 90. And the fees, these fees wouldn't be on here if he would have helped pay. And that's what the tax woman said. These fees wouldn't even be on here because you need more money. All I'm doing is paying on it, trying to keep it out of that foreclosure state.
Okay, so you have paid whatever 2 times $392.74 is that what I'm hearing?
2,100.
You are asking him to pay $1,392.74 in taxes, and I want to know whether that represents half of what you have paid or whether that is his share of those taxes that should be paid to the county.
That is half of the fees and the taxes.
That you have paid,
That I cut in half.
that you have paid?
Yeah, I got on a payment plan and was paying like $180. And I would then, if I had, I'm on disability. If I had $200, I'd put $200 on it. I paid off the taxes for 2021. So I guess I could take the fees off there.
Well, if the fees were charged as part of the tax process, you don't have to take them off. The bottom line here is I want to know whether that money should go to you or whether that money should go to pay additional tax obligations, because it sounds like we've got additional tax obligations on this property.
And our property is selling right now. They are in contingents. And he's to pay all the taxes at the end, what's left over, and all the closing cost.
All right, and with regard to the repairs that were done, are those repairs due to your use of the property, or are they general maintenance of the property?
Well, let's see, when it comes, the septic tank, well, I'm telling you, the septic tank had to be emptied like 6 months after he left. So,
Okay.
you know, and then, you gotta have water, you gotta have your plumbing fixed, so.
She is so rude. I can't believe she speaks to the judge this way.
That's maintenance, and the furnace, had to get a new igniter and a sensor put on it.
Okay. All right. It does appear to me, based on the agreement the parties had as part of their divorce, that they were to share in the expenses associated with the taxes and maintenance of the property, upkeep of the property. The defendant agrees that he owes taxes going back to this 2021 or 2020 tax period, pardon me. And the amount with the additional fees due to late payment that is owed to the defendant is $1,392.74. I am going to order that be paid to the defendant. How long do you need to pay that, Mr. Schaub? Simple question.
He can pay it at the closing.
Mrs. Schaub, did you hear what I said? You have to wait for me, okay? Mr. Schaub, how long do you need to make that payment?
I'm gonna have to wait till the closing because I can't come up with that kind of money right offhand.
All right, that'll be paid out of the closing between the parties.
Suddenly, it's not such a big deal. The first hearing, it was, you know, she made it out like he's this giant turd and hasn't done anything, and she's on Social Security, so she needs this now, and now it's like, oh, he can pay it out of the closing. Did I get close to the voice? I tried.
And that's the closing for the sale of the subject property. So it'll be paid by from the plaintiff's share to the defendant. As to the repairs to the septic, I think the septic is a normal expense that is generalized upkeep of the building. It certainly is a benefit to the sale, so I think that should be paid. The plumbing expenses, it sounds like that was for general provision of water. That also is a maintenance issue, as is the repairs to the furnace that appear to be also having to do with furnace functioning. If we were talking about replacing filters, for example, I wouldn't order those. That's normal everyday use, but these are more substantial expenses. So I'm also going to order that the plaintiff pay at closing of sale of this matter $724.36 to the defendant, representing the outstanding expenses associated with upkeep on the property. Now, in terms of an order, you're going to need an order for the closing agent so that he or she can move those monies appropriately. I don't know that I'm going to be able to get either of you to prepare an order, so I will have my office send out an order that affirms our decision today. Okay? All right.
Okay.
Thank you both. Take care.
Thank you. Thank you.
All right, Omari Jackson, let me find your paperwork. All right, Mr. Jackson, can you hear me?
Yes.
Okay, thank you. This is in the matter of Aaliyah Packard versus Omari Jackson, file number 2015-41484DP. So Mr. Jackson, we are here on a show cause for failure to pay child support. It states here you're ordered to pay $244 a month in child support. As of today's date, you have an arrearage of $1,736.71. This is your second show cause. The last payment we received was $113.79 back on May 19th of 2025. So, Mr. Jackson, yes or no? Are you currently employed?
No, ma'am.
Okay. So, Mr. Jackson, do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes.
Do you understand, because it's a second show cause, if you were to plead guilty or be found guilty of failure to pay child support, you could be facing up to 90 days in jail?
I have a question. Why is there a second show cause? Because I was at the first show cause and they told me it was adjourned.
Yeah, and now we're back again today. That's all. Wasn't it adjourned to today?
Yeah.
Okay. I don't rephrase your question.
Never mind. I'm just curious is all.
So they probably initially show caused you and then you're being show caused again because you still haven't made a payment.
I mean, they told
So
me
it was
that I had to come
adjourned.
back. Well, they didn't tell me. They didn't tell me. They didn't. This isn't. For one, I haven't gotten anything in the mail. And they told me it was adjourned to come back today. They didn't say anything about that. I had to make a payment or anything or show anything. They didn't tell me anything. They told me to come back to court today.
Okay, Mr. Jackson, they shouldn't have to tell you to make a child support payment because you're ordered to pay it. So whether, every month you're ordered to pay $244 a month. So the assumption would be if it got adjourned, you still got to make those payments, right?
I mean, understandable, but I can't make it if I don't have anything to make it with.
Okay, so
you know what makes that easier? A job.
When's the last time you had a job?
I lost my job in June.
Okay.
Of this year.
And where you were in?
I just got off of felony probation. I just got off felony probation.
Okay, I supervise hundreds of people with felonies who have jobs. So that's no reason you can't have a job.
There's nowhere. I'm supposed to be at Michigan Works this morning. I was supposed to be there at 8:15, but I forgot that I had this court date to try to see about getting a job. But as it stands, where I live, there's nowhere for me to work with a felony record.
So, Mr. Jackson, you still got to make your payment. And understand, if you reach the 10,000 level, you're going to have another felony. So, Mr. Jackson, you have a right to have an attorney represent you on this and all subsequent hearings. Can't afford to hire one, we will appoint an attorney to represent you. Would you like a court-appointed attorney?
That's fine.
All right, so I'm going to put you in a waiting room until we get our court-appointed attorney here, and then she will have a moment to talk to you. I'll pop you in the waiting room. Miss Adams, did Miss Underwood get sent Mr. Jackson's paperwork?
Oh, no, I'll come get it.
Okay, we're going to send it to you right now. Mr. Jackson, I am going to put you in a breakout room with Miss Underwood. We're gonna send her your paperwork and then that'll give you a chance to talk to her, okay?
Yep.
All right. Mr. Jackson, if you want to go ahead and start your video and your audio. All right. So, Miss Underwood, have you had a chance to speak with Mr. Jackson?
I have, Your Honor.
And how would you like to proceed today?
I would ask the court to enter a not guilty plea on Mr. Jackson's behalf. Mr. Jackson, Your Honor, unfortunately lost his job and is looking through workforce for another one. In addition, Your Honor, I find it kind of, I believe this is the case, that Mr. Jackson, on another matter, maybe owed like $7,000 in arrearages on a child support case he has. So I would ask the court to set this matter over till January 26th. I've asked Mr. Jackson to document each and every employment opportunity and hopefully by the time he comes back on the 26th, Mr. Jackson will have employment.
Well, she certainly phrased that better than he did, but may have like $7,000 child support order coming to him that he's owed. May. I don't really think so, but I could be wrong. I could be wrong.
Okay, and what county are you owed child support, Mr. Jackson?
I'm owed child support from Wayne County.
Wow. All right. So, Mr. Jackson, you did say you were working through one of the employer programs. I realize you live somewhere, maybe it's hard to get employment, but that's not going to work. If you got to get a job, you might have to move. So I'll set this out to January.
Ma'am, I don't know how I'm gonna move. I own my house. I can't just up and move.
Do you have a driver's
I have
license?
kids.
Do you have a driver's license?
I have a driver's license, but I don't have a vehicle.
Okay, we'll adjourn this over to January 26th. And you need to have employment by then, Mr. Jackson. Thank you.
Jose Delgado?
Yes, ma'am.
Hey
Sorry.
there, how are you, Mr. Delgado?
I'm doing all right. How about yourself?
Good, making us all jealous with that nice sunshine.
It's nice now. It was cold this morning.
It was cold this morning. I know. I was out there too. But right now I'm in this like shell of no sunshine, no windows, no nothing. So anyway, I'm a little jealous. Mr. Delgado, any questions about the rights I went over earlier?
No, ma'am.
And we've got one ticket, speeding in a school zone is what they've alleged. You were going 30 miles per hour in a 20 mile per hour zone. That was from Halloween, October 31st, 2025. Do you recall that situation?
Yes, ma'am, I do.
And how would you like to plead, Mr. Delgado? Would you like to plead guilty, not guilty, or no contest?
I honestly feel like I wasn't guilty that time. I feel like I was racially profiled, but no, I'm gonna plead guilty, ma'am. Sorry.
Well, are you sure you were?
That I really don't really want to try and challenge it. I just don't feel like I'd win. The school zone says it stops at 4, but my ticket, 4 or 3:30, the school zone stops, but he's saying he caught me going over the speed limit, but it was 4:31 by the time the ticket was issued. I doubt we were in a pullover situation for a whole hour. I really feel like it was just him patrolling his girlfriend's area where the school was, because he had a female ride along, and then he was picking up a child at the same spot that I was apparently speeding in. And he pulled me over right there, right next to the child that he was picking up from the school, put in the back of the cruiser and all. But I really just don't feel like it'd be a winning case for me. So I'd rather not.
I don't know, Mr. Delgado. You've given some pretty compelling problems with your case.
No, I called the sergeant on everything because he pulled me out the car, ma'am, and like there was no reason. I have no felonies. I have nothing on my record. But he felt the need to pull me out the car because I gave him attitude because he asked me why I didn't have my driver's license, and I gave him the reason why, because I lost it here at work in one of the trenches, and I work from 6 to 6, so I don't have time to go get another ID. And I explained that to him, and he told me, why don't I go online? And I told him why I didn't go online, because I already used up my 2 times. And then he just started getting smart and like a real attitude about everything. I'm like, all right, officer. And the video camera shows it all. I had to ask for his name and badge number. He told me to get off the car. When I got off the car, he pushes me against the car, and he's telling me that for me not to get back in my effing car. And it was a whole scene, ma'am. It was honestly, but I don't
This
want to try
sounds
and
like
go.
a whole scene. I mean,
I called the sergeant and everything, and the sergeant said that he did nothing wrong besides belittle me and go back and forth with me about the driver's license. But that's the only thing that he did wrong due to the due to that new law, state versus NIMS or whatever. He has every right to pull me out of my vehicle. He doesn't need anything other than my ethnicity, I guess. And well, I honestly feel like it was just I was in his point in time. He was picking up his kid. He seen me, and he felt the need that, okay, well, this is, or his kid, his girlfriend's kid. The sergeant actually started yelling at me and telling me, I'm sorry for my language, but he says, is it effing wrong to be human and pick up and hug a kid? I'm like, no, officer, he's not picking up and hugging a kid there. He was picking up the kid and getting him into the police car, and he had that woman out his ride along with him the whole time this situation was going down. I was just simply asking him for information, like, what am I getting pulled out my vehicle for? You know, what is this all about? And he told me it was about the school zone, ma'am.
Yeah, speeding in a school zone. That's, kind of an offense. And as far as, him picking up the kid or, having the ride along, well, we don't know whose kid it was, for one thing. It could have been something like a state-run program or a county-run program of, where police officers engage with kids in the community. Or like around here, certain departments, the officers take their vehicles home. The guy that lives across the street from me that recently moved in, the cop car is there like every day because he takes his vehicle home every day. So it could be that he just got done or was getting done with his shift and he was grabbing his kid before he went home or something like that. I mean, I really don't think that that's such a big deal. I don't think that's a violation on the officer's part. But this guy has already admitted to several violations, and I don't know why the judge is coddling him.
But the school zone stops at 3:30. I looked at the sign because one of my buddies told me, why don't you look at the sign? And yeah, the ticket's not issued until 4:31. There's no way that we had a whole hour of a pullover.
So I guess my question, so the officer was in a marked patrol unit, is that
Yes,
correct?
ma'am. Yes, ma'am.
And he had a passenger in there.
Yes, ma'am. And apparently the sergeant said
And he was picking up a child and putting the child in the marked patrol unit.
Yes, ma'am. On the video and everything, it shows where I'm telling him, officer, I don't know if you're putting on a show for the woman you have standing right behind you or the child that you have sitting next to my car, but I'm speaking to you, right? And I'm just trying to tell you that this is why. And then that's when he told me to get off my effing car. And I'm like, sir, I have no reason to get off my car. I said, to be honest, I'm scared. I don't want to get off my car. And he told me, get off your vehicle now. Oh, ma'am. I'm sorry for just rambling, but this was a whole ordeal. And he even threatened to arrest me right then and there because I didn't sign the ticket. I said, sir, I don't feel like I should sign this ticket because you're forcing me to sign this ticket. You have me scared behind my vehicle, out of my vehicle, when I've done nothing wrong. And ma'am, when I said no, he put his hands on his waist. I didn't know if he was going for his gun or his handcuffs, But then he went for his handcuffs and he was like, get against the vehicle. And I was like, man, I stepped back, ma'am. And it's all on his body cam. I stepped back and I was like, whoa, whoa, whoa. I said, no, I'm not going to jail for not signing a ticket. He says, yes, you are. You either sign this ticket or I take you into jail right now. And I was like, officer, I don't feel like I should have to sign this ticket. And I have a video where I'm asking him for his name and badge number. I had to ask him 12 times until he seen me bring out my phone. That's when he wanted to bring out his name and badge number. And then I confronted him over the fact that his eye was twitching, because he's the one who said that he pulled me out of the car for being upset. But it's like, officer, I gave you my answer multiple times and you're the one that's over here, your eyes spazzing out. He was like, what does that have to do with anything? I'm like, sir, if you're emotional about this, you need to step back. But basically, ma'am, I really don't feel like I'm guilty for that, but I'm too scared to try and fight it, so I'm just gonna go ahead and plead guilty. But it's all on body cam. But main reason I don't want to do it is because I called the sergeant, I talked to the sergeant talked to me like I was dumb for even trying to call about any of that.
Okay, so can I talk for a minute on this?
Yes, ma'am. Sorry.
Yeah, no. I'm glad here's the deal, Mr. Delgado. You know that, and I understand fear. I get fear, but I'm independent from the police department. The police department utilizes my court to file tickets, right? That doesn't mean I don't answer to them. I'm completely independent of them, right? So, and that's by design. It allows us to be the court system, to be judicial system as a whole, to be an arbiter of these situations, of what happens and what occurs. So Mr. Delgado, I mean, you have mentioned several things that definitely concern me. I don't think it would be a waste of your time to visit with the city prosecutor. I don't think there's any fear that you need to worry about in our department and in our court.
Oh, okay. I was say I'm fair to him because I feel like he did the most. He took pictures of me from his vehicle when I was asking why I was pulled over. He was taking pictures from the steering wheel. He made sure he got my number, my address, my apartment number. He got everything from me, ma'am. Because if I didn't give it to him, I was in trouble.
He is not here. He is not in court. He is not. I mean, this is our separate department, our separate entity, and it's an imperative that we stay independent for situations just like this. But Mr. Delgado, look, if I don't know what will come of visiting with the city prosecutor, but we take these types of allegations seriously. And if his sergeant did it, or whoever his hierarchy is over at the police department didn't, well, then guess what? That's on them. But we can take these things seriously. We can do what we need to do to figure out. I mean, you've made some serious allegations here that I think are really concerning, right?
And it's all on body cam, ma'am, because the sergeant said he saw it all and that the only thing he did wrong was go back and forth with me about my ID. But ma'am, he pulled me out of my vehicle. He had me scared. He threatened to arrest me for not signing a ticket. But it was
that does sound like a Mr. Delgado, with all due respect, that does sound like a very scary interaction. And I can't imagine what the people around you
make it
were
a racial issue, but it was an all-white cop. He stopped me and he made sure he wanted to know who because I'm in a 2026 Chevy. You know, it's a nice vehicle, and I was wearing a muscle shirt. I was covered in dirt. I looked like, I looked like a real Mexican at that point. And
I'm not trying to make this a racial issue, but it was an all-white cop, and I look like a real Mexican. Are you kidding me?
I honestly feel like that's one of the main reasons he pulled me over, because he bring out that new law. It was mainly over the fact of the ID. That the sergeant even said that it was mainly over the fact of why didn't I have my ID. So I think it was more because they took pictures of me and everything from the inside of the car, and I think it's because they probably thought I was like an illegal at that point.
Yeah.
So I just really I didn't know how to handle the situation or what to even do. I didn't know if there was gonna be retaliation on his part, because I've been pulled over, I've been arrested a couple of times, but never have I had them ask me for my address, my apartment number, my phone number, my company number. where my company's located. He got all that from me.
That's crazy.
So if talking to a prosecutor would help, I'd love that, but I just don't want to hit a dead end and really make enemies along the way.
Well, no, I don't want you to make enemies either. And by exercising your rights, you're not making enemies. I mean, if I don't stand for that, then what in the world am I doing in my current job, right?
If you are going to undermine law enforcement in their duties of protecting the public, add to the discourse and the disrespect of lawful authority and side with the person that admitted they had an attitude with the officer and committed several violations during the stop, then what the hell are you doing in your current job?
Like, yeah. Mr. Delgado, you wonder why people tune in to the municipal court in the city of Victoria. This is why you've just given everybody's like, look, everybody's even on here. They're like watching. They're like, what's going to happen next?
No, I wish it wasn't true, man, because that day I was just like, I
wish it wasn't
have
true
nothing
too.
on my record
Here's
to
the
be.
deal, Mr. Delgado. I wish it wasn't true too, but that's why we really need to be real clear and like what your options are at this point. And I think it's important that I don't know what happened. I can hear what you're saying. What you describe is very concerning to me. What you describe is I would be extremely fearful if I were in your situation. What you describe is problematic for sure. I don't know what the body cam says because I'm not in charge of the evidence, but the only person who is in charge of the evidence, the only person who has that evidence is the city prosecutor. They're the ones who make charging decisions. And that's why I think it's important for you to maybe spend a little bit more time and go and visit with the city prosecutor about this situation. He is the person who is given the ability to take a further look into the situation to see if there's misconduct or to see if there's a problematic behavior and that's certainly what you've described today. So, I mean, I know you don't.
I was just going by what the sergeant had said. He was saying that there was nothing wrong in any of that situation. But ma'am, I
well,
felt
the sergeant's not the boss of me either, like that's the cool thing about being the judge.
So what do I plead? Not guilty?
Well, right now we've got everybody's attention. Everybody raise their hand. What do you think? You think he should just sweep this under the rug, enter a plea, or you think he should maybe take the time? Oh, we got a no over there. Take the time to visit with the city prosecutor. Raise your hand, everybody.
Really?
All right, look, everybody's giving you some, it's called, what they used to call it, call a friend or something like that. You just got to call a friend. Look, no, and here's the deal, Mr. Delgado. In all seriousness, this is a serious situation. Like, I'm not trying to make light of it, okay? I'm not at all.
No, ma'am, I understand.
I'm just trying to make sure you understand you've got some options here. And just entering a plea, I never want anyone to enter a plea that is not correct. I really don't. I mean, that is just the antithesis of what I stand for. So,
it's just, I'm actually a single father of 3 kids. And I just didn't want to go to jail for something like, trying to fight it and then be like, oh, well, then this and that. And I can't do it.
You're not going to go to jail. We got no warrants. I
got a warrant. Yeah, there's a warrant for this ticket.
No, there's not. It's warrant pending, but right now you and I have visited, so that resets all of it. So there's not going to be a warrant. Where I think we'll send you, I mean, if that's what I'm hearing you're wanting to do, maybe go visit with the prosecutor today and we can kind of work through this, okay?
Yes, ma'am. I'd appreciate that, please.
Okay.
I appreciate the support because I just wasn't sure, I really felt like I got bullied into the ticket. I mean, if anybody can see the video that I have or like the body cam, like I said, I have the video. I asked him multiple times for his name and badge number. He didn't want to give it to me until I busted out my phone. And that's when he was like, well, wait a minute, let me read you your rights. So you just read me my rights and you told me everything. You're just repeating yourself now because I have my phone out. But I just didn't know what to do, ma'am. But yes, ma'am, I'd like to speak to a prosecutor if possible.
This is what we do. Yes, you go visit with the city prosecutor. I'm going to transfer you over there, okay? And
yes, ma'am.
If you like what the prosecutor has to say, great. If you don't, you can always ask to come back and visit with me and we'll talk about next steps, okay?
Yes, ma'am. I appreciate you.
All right. I hope you have a good holiday, Mr. Delgado. And I'm sorry that you've gone through something as traumatic as this, and it's unfair and not right. And I'm glad you're visiting with him. So hold tight. Just to be sure, Mr. Delgado, I do have an email address for you at Gmail. Is that the best one?
Yes, ma'am.
Okay, sounds good. Hold
I
tight, okay?
appreciate you.
When
You have
you
a good
get
one.
that invitation, you're going to say accept, okay?
Yes, ma'am.
All right, thank you.
Oh, that one made me so mad. Oh my goodness, it was infuriating. I was screaming at the screen. Squishy walked in on me and I'm just rage typing. And you know what? I usually like her. She's very compassionate, very empathetic. This right here, this completely, I have no respect for her anymore. None whatsoever. This was complete bias. She absolutely undermined all of the officer's authority. She told the guy at the end, "Oh, this is so unfair to you," without having any proof or evidence of the situation. She does not know how that stop went. Clearly, she does not understand what officers have to go through on those stops. The guy admitted to giving the officer attitude. He refused to get out of the vehicle. He refused to sign the ticket. The guy was clearly being a jerk to the officer. Did the officer go overboard? I don't know. I wasn't there. I'm going by what he admitted. It just, oh my gosh. It made me a little mad. I was like, how am I going to run this hearing? I'm going to pause it every 3 seconds. Every couple of words, I'm going to be pausing it to yell. I'm like, oh, I will just type my opinions. And I didn't even type all of them. I think I behaved myself quite well. Oh my gosh. Doing the most. He claimed the officer was doing the most. He was doing the most. Oh, that made me so mad. I'm sorry. That judge, she has no business on the bench if that is her position, to take the criminal side or the person being accused of an offense, to automatically take their side when they have admitted they're in the wrong. And to completely push the narrative of, oh, well, yeah, that had to be traumatic. That had to be scary. Oh, yeah, I don't know if she agreed with him that it was racial profiling, but she sure let him believe it. She let him believe all of his BS. That is clearly someone that does not understand the law enforcement side of things. I'm sure if she was appointed, I'm sure she was a defense attorney. Oh, man. Okay. Time to make me happy. Charlie sent me presents, and I can smell it. And it's just in time, too, because I only have one bag left of the 6 bags of 8 o'clock bean coffee that I got from a secret admirer. I did share with my daughter the 8 o'clock bean coffee. Okay, I thought these packages had a little pull here tab, but I must be mistaken. Oh my goodness. We have black velvet. Ooh, and it's one of those bags that has all kinds of fun little words on it. Spread positive energy. For 2 decades, our family has used coffee as a catalyst for inspiring community, relationships, and adventures. Hey, that's what I do. And then diesel. Ooh. Let's see. Diesel is smoky, baker's chocolate, and dry finish. And black velvet is burnt sugar, graham cracker, and malted milk balls. Ooh, I think I'm gonna like the diesel. Well, I'm gonna like them both, but the diesel smells like right up my alley. There's lots of coffee glitter that comes in the bags. It's all over my desk. I think Charlie does this just to see how much of a mess I make when I open his stuff. Thank you so much, Charlie. Oh my gosh, it smells so good. I can smell the smokiness of diesel. Like you can smell the smokiness. Okay, real quick, I have to squeegee my desk with my hand real quick before I can use my mouse because I have coffee everywhere. Here. Yeah, it blew up. It blew. Oh, I got it on my keyboard too. That's not good. Hold on. I have to do this with cat fur and cat treats all day long. Like, Ava, I picked up the garbage can and Ava sat right where it goes. That's the garbage can spot, silly. There. Give it a good blow. No, Squishy, you do not have to make a short out of that one. Look at me. I'm all raggedy looking. I took a shower right before I started streaming, so my hair is like all dry and stuff. Well, that and the weather. They are. I already can tell. I love them. I know that diesel's gonna be good. It's just got that smell. Oh, I loved your care package. Wolf Floor Lover sent me sausage. Well, so Earl is napping because he I don't know if he's forgiven me yet. I don't know where Billy's at. Billy's probably napping too. So I decided I'm so tired of Bandit and Earl just constantly constantly being at war with each other. And there's not really any way, like the internet says, you keep them separated and then you slowly introduce them to each other again. It doesn't work with Bandit. Bandit never forgets. Bandit, she's a special kitty. So I had this cat named Crow that was living in my car with me when I was homeless. And at some point I asked my mom if my mom would take Crow. And living in a car with a cat is really hard. So it was just supposed to be for a couple months. And Crow and Bandit did not get along. And coffee everywhere. Whenever my daughter, well, after I took Crow back, and we were, you know, living, I think it was here. Yeah. It was here, and Crow came back to live here. And whenever my daughter would go visit my parents, Bandit would smell Crow and just bolt. And Kendra was Bandit's favorite human prior to Crow. Bandit does not ever forget. And so today I put Earl in the carrier tote and I gave them each a dose of Gabby, and I had Crow in Bandit's room in the carrier tote, and they both sat there just hissing at each other, just hissing away like crazy. And but then Earl went into manic panic mode, and he was just scream meowing. And I was like, you know, you're just gonna sit in here with me, buddy. I'm gonna take a shower. And the entire time that I took a shower, he just meowed loudly. And I gave them each treats. And I could always tell when Bandit would move, because Earl would like let out this ungodly scream of a meow. And oh, man, I'm hoping that introducing them to each other in a controlled environment like that, if I do that enough, I'm really hoping that eventually they'll stop seeing each other as a threat. But I'm thinking Earl might be still under the influence of gabapentin, because it's really only been a little over, well, I don't know, 3 hours. So anyways, that's the story of that today. When I first started streaming, I like, people would be talking in the chat about all different random things, and I would stop the case and I'd be like, ooh, red carpet story time. And and I'd go on story time and then start the case again. It was terrible. The chat is my thing, you know. The court cases are, you know, they're just extra. And they're just something that we all bond over. Oh yeah, yeah. Earl and Tiny Kit words. Earl and Tiny Kitten Esquire are a pair. Bandit loves Billy. Billy's terrified of Bandit. Earl hates Bandit. Tiny Kitten Esquire does not like Bandit. But Tiny Kitten Esquire isn't so bad. Like, you can tell when she's in her mood. Like, it's a jealousy thing. She's like, you're by my mom, I'm gonna get you. With Earl, it's just an all-out attack. And see, oh, and Billy hates Tiny Kitten Esquire. Same thing, all-out attack. They will fight and roll and do that whole Garfield, Heathcliff, the circle smoke bubble with legs and arms and paws everywhere. Yeah. That's all you see. And they'll always start upstairs, and then they end up chasing each other into the basement and knocking stuff over, and it's just a nightmare. Oh, I know. Oh, they get plenty of catnip. For one, I grow catnip, and then I always have extra. and they get plenty. It's just, I think what it is, Earl's the welcome wagon. Hi, Earl. Was I talking about you, baby? Come on. Earl's the welcome wagon, but Earl likes to sniff butts. Yeah, I'm telling on you. And I think Bandit felt threatened when Earl was sniffing her butt. And so she probably hissed at him, which then in turn caused him to lash out. And from there, they became mortal enemies. Heathcliff, no one could terrorize the neighborhood. Hi, Earl. Oh, and then there's Ava being all jealous. Hi, Earl, baby boy. How's my sweet baby? How's my sweet boy? Oh my, you are jealous. All right, guys. I'm going to take off because I really think Ava has to go potty. You gotta go outside? Or are you just jealous? Is that all? Pretty much. Yeah. Earl took a shine into Ava, and Earl fought for 2 months to get Ava to like him. Ava hated Earl, and now they're besties. Now they're bestie butt sniffers. Hi, baby. What's up? What you want? You want sketches? You want sketches? Oh. Thank you guys so much for coming and hanging out with me tonight. I had so much fun with those cases. All right, you gotta move your kitty butt. Don't you step on that keyboard. You pull a Billy. Felix. My dad always had a Felix doll. Always. I remember that black and white Felix doll. Earl, what's up, buds? Oh, you guys should see my back from where Earl climbed my back. Oh, man. Scratches from my shoulder blade all the way down. Hey, thank you so much for joining us tonight, by the way. It's so great to have a new friend here. Be safe, be well, sleep sweet, and much love.